So, welcome back to this discussion. I know that you find the climate a little bit bit challenging now with the sun coming in, but I can assure you it won't last. Please, so just enjoy this slight change of climate. Okay, so welcome all to this session on new paths in climate litigation. And the climate emergency is weighing really heavily on all of us, I think, in this room. And it's certainly an area where the courts have been seen maybe also from a perspective of like desperation, that other things, just other arenas and avenues are challenging and closed, and the special nature of the courts, at least in the beginning, it was, I think, for lack of alternatives, and then we've seen that the courts litigation have been used with a lot of creativity, with a lot of ingenuity, and with very good effects, particularly in creating awareness. So in this panel, we'll hear about some of the new trends in climate litigation and some of the variation in which climate litigation is being pursued in different parts of the world. And this is an amazing panel, and you should, and it's actually a panel by serendipity, because of the first person who will speak, Catalina Vallejo, who first, I mean, it was almost just by accident that you started working on climate change more than 10 years ago, and we worked together, and then you pursued your PhD at Los Andes University in Bogota in Colombia, but also in Bergen at the time at Law Transform, and then went on to do a PhD on a postdoc as well at the University of Bergen at the School of Law. And Catalina is now teaching at the PhD course that we have that is part of the Bergen Exchanges, and has been teaching in other PhD courses. But this year she's teaching on the PhD course. And actually all the other panelists that you're seeing here applied for the PhD course. And they are doing their doctorate work on climate litigation or related issues in different universities across the world. And many of them are also very accomplished scholars in other ways and have a lot of experience before pursuing their PhD. And this is really, as you all know, you're never as cutting edge as when you are working on your PhD. So we really, really get the best. So I already made a presentation of Catalina. So maybe I'll just and then we'll have, so the format is like this. So Catalina will speak first, and then after Catalina, Talia will speak. Talia Viveros Uahara, who's doing a PhD at the University of Massachusetts, but also at the Max Planck Institute, and also working currently as an intern researcher at the Boston Human Rights Commission. And she's an environmental and human rights lawyer, working at this intersection on environmental protection, water conservation, poverty alleviation. And it is in this intersection that she will speak about the use of health litigation within climate litigation. And then she's also been an advisor to the Mexican Senate and a director of advocacy and civil society participation at the National Human Rights Commission of Mexico. So a lot of relevant experience. Amazing. And then after Catalina and Talia have made their presentations, we'll have shorter interventions from the rest of the panel, and I'll get to them afterwards, so you will then remember. So, but first, Catalina and Talia.
Okay, yes, so it wasn't by accident that I started working on climate change litigation. The accident is called City Globeman. I was working on legal issues, but mostly the intersection between peace and conflict studies and law. So focusing on transitional justice, and then I was doing different like research assistant things for the CMI. And then City had this project with Jackie and others on climate change litigation. And she asked me, can you please help us map litigation around the world? And I said, yes, not my topic of interest, but yes, sure, I can do it. And then I started doing this and I completely fell for the topic because of its complexity, like different causes, consequences, different disciplines involved. And just, I thought it was a very interesting, complex topic that needed a lot of creativity from all of us, different disciplines. So at the time we did this mapping and we found out that there was already a lot of litigation. This was 2012, if I'm not wrong. There was already a lot of litigation. So people around the world, communities, citizens, lawyers were using the courts kind of to bring their frustration because democracy, like the political branches were not good, working well for this topic. So legislative bodies didn't really want to pass proper legislation. International law was not working completely well for this. Yes, so the judiciary became kind of a place where people could bring their frustration, but also really challenge and use the checks and balances system to challenge their governments and their legislative to do more or better or to start doing something in the first place. So we saw a lot of litigation and we decided, so we mapped and we saw, okay, there are uses of criminal law, creating, for example, crimes against deforestation and other things. There are suits against private corporations, the fossil fuel industry, to ask for damages after hurricanes or things like this. Not successful. And then we saw also that there was quite an interesting amount of administrative and constitutional law litigation, so cases against governments. So this was the mapping exercise. And from there, we saw that mostly all of it was not successful for the petitioners, like for climate protection claims, but administrative litigation was a little bit successful because, so we've been trying to understand why, but part of it is the litigants used the already existing environmental law, constitutional law, human rights law, even procedural law to challenge governments to do the same things they used to do in other topics, but also for climate change. And it was kind of impossible for them to say no, because this was the reality of the existing law. So they had to do it. And we saw this as a promising path. So then afterwards, I already fell in love with the topic. Then I met Cesar Rodriguez and he said, I think this is a very important topic. And then I started my PhD on this and forgot about war and peace. And now I see all the interconnections between the two. And it's interesting because after all these years, so what we see is, yes, since maybe the 70s, 80s, scientists have been very actively warning politicians and civil society about the fact that there are some air pollutants that stay in the atmosphere and that this messes up with the climate system of the planet and that this brings very harsh consequences. And that this was not in the far future or like 4 generations in the future, but already starting today. Then in 92, we see movements in international law, 97, the Kyoto Protocol, then in 2015, the Paris Agreement. So at the international level, we see a lot of legal creation and reform. Also, we see that this it's kind of in the fabric of everyday conversation now. So maybe 20 years ago, climate change was just the topic for environmentalists or scientists. Now everyone can speak about the climate crisis. Now we turn the TV, is there, everyone talks about climate change. So that it's perhaps a success to bring the problem to everyday conversation and reality. Yes, so changes in international law, I think at the domestic level, after the Paris Agreement, most states have actually created climate change acts, statutes, regulations, even institutions, no? There are new institutions. And we still see climate change litigation. And now, so according to the Grantham Institute, that produces a very interesting report every year about the global trends in climate litigation, they say that climate change litigation continues to grow in importance year on year as a way to either advancing or delaying effective action on climate change. In 2022, the Intergovernmental Panel on Climate Change recognized the role of litigation in affecting the outcome and ambition of climate governance. And the cases since 2018 have doubled today. So it's really, people are using this more and more. So we see all these changes and it's interesting and we've seen important things happening. However, when it comes to the actual causes of climate change, so greenhouse gas emissions and deforestation mainly, both continue to increase. So they are not being reduced, they both continue. So now we are facing this reality where, okay, we have done fairly well when it comes to legal reform, and even when it comes to litigation, and very interesting case law has emerged from this. Very famous Urgenda case where the judiciary pushed the government to increase its ambition in its public policy for mitigation, and many other important cases in Colombia, the Amazon, deforestation in the Amazon, where the Constitutional Court, the judiciary pushed also the national government for really creating new regulation against deforestation, including climate change in development plans and many things. So this is, and even saying that the Amazon was a subject of autonomous rights. So we've seen things, but the reality isn't changing. And every year we see more heat waves, we see more landslides, we see more forest fires, and we see more and more of the vulnerable communities who now, we are all vulnerable communities, but of course inequalities in society make also an effect in this topic. Really, the frustration continues. There's more litigation, but the frustration continues. And about the new paths. So we already mentioned litigation against corporations, against governments, the use of criminal law, the use of international law. And perhaps what's new right now is, so people continue to push for better regulation or for governments to act or implement their international commitments on climate change. But also there's been a very important turn to human rights litigation on climate change. So the rights to life, rights to health, to livelihood, to water have been very important. And even new subjects have been, new subjects of rights have been included in this debate. Very importantly, the unborn, future generations, children. Yesterday we had a panel on children. Can someone speak for the children, please? In climate litigation, this is also a very common phrase. And interestingly, Article 8 of the European Convention is also used for litigation of climate change and human rights. The elderly, there is a famous case brought by elderly women, female citizens, claiming against Switzerland, saying that they are very especially harshly affected by the heat waves, and their health problems are different than from other sides of the population. And also non-human subjects. So as the Amazon, now we start seeing more claims about animal protection, biodiversity being a key element in climate litigation, the rights of rivers that we will discuss later today as well, rights of mountains, rights of glaciers. So this is among the new paths. And two more interesting things are the more detailed discussion about environmental impact assessment of carbon intensive projects, especially scope 2 and 3 emissions. So not only those that come from the activity of extracting fossil fuels from the ground, but also when you extract them and sell them to someone else and sell them, you are also, this is the debate now, you're also responsible for those emissions, or at least there should be a shared responsibility or accountability somehow. And this has been absent, not in the debate, but yes, in litigation and certainly in decisions. So this is coming up, and also like really paying more attention to environmental impact assessment, because so far this has been about soil pollution, water pollution, local air pollution, how communities are affected, biodiversity, but not about the atmosphere, no? So how carbon emissions also affect the atmosphere, and this affects the global climate. So this is hopefully, in my opinion, an important side of litigation that hopefully will develop much more. And another one is the focusing on short-lived pollutants, not only on CO2, but also on those emissions that stay for a shorter period in the atmosphere. And if the logic is, if we focus on limiting those right now, then we will see a more rapid change, at least that give us time to get other systems in place. So this is also an avenue that it's quite important now. And to finish, cases against corporate actors are increasingly targeting the food and agriculture, transport, plastics, and finance sectors more than before. And the litigation is about increased ambition, more and more about increasing ambition from states to phase down the use of all fossil fuels across the energy sector. Yes, and of course on the energy transition, creation of new technologies, energy efficiency strategies, etc.
Thank you so much, Catalina. Excellent. And you also you gave the keyword for Talia on the role of human rights in the litigation, but also litigation focusing more on adaptation, which is also a set of how do we adapt to climate change and the intersection of justice and climate in that. So please, Talia.
Thank you, Siri. Thank you, Catalina. It's a real pleasure being here at the Bergen Exchanges 2022. This is a precious opportunity. And talking about the new paths on climate litigation cannot be timelier. On the one side, because of what Catalina just mentioned, climate litigation is just proliferating worldwide. But at the same time, on the other hand, due to COVID-19 and the economic slowdowns that it has caused, poverty alleviation efforts that have taken place during the past decades have experienced major setbacks. So these are the two phenomena that bring my topic together. On the one hand, this huge proliferation, but on the other side, these structural socioeconomic problems that we are still witnessing all around the world. And I argue that health is one of the most acute dimensions where poverty, social exclusion, and climate change come to cross paths. Not only because, of course, the direct impacts that climate change poses on the health of human beings, but also and crucially because these impacts increasingly find socially marginalized communities unprepared to withstand those health issues, as they lack access usually to resources, to healthcare services that would allow them to cure and rehabilitate, to prevent, cure and rehabilitate those conditions. So I'd like to ask and take this opportunity to ask and bring forth the question, is climate litigation really a new path to address this pressing and intertwined issue between social exclusion and climate change? Are litigants and courts really dealing with it? And if so, how they are doing that? And resolving these questions is, in my view, the tip of a broader iceberg, which is climate litigation pro-poor? And if it is the case, how and why? So because I am highly intrigued by these questions, I'm exploring through my PhD research project how health crises emerge within and how they are being tackled by courts through rights-based litigation, and my particular focus is in Latin American jurisdictions. So to do so, I draw, and I'm really thankful for that, on the theoretical and empirical foundations that have been laid by important and seminal works by Siri, by Camila, by Sandra Botero, who's there, by Daniel, by Roberto. So it's for me a real honor being here. I particularly draw on Siri's analytical framework to really untangle the anatomy of the litigation process that would allow a comparative approach across Latin American jurisdictions. So as a first step, what I did was to apply content analysis to the body of rights-based climate litigation that has been filed thus far across Latin American jurisdictions. And but before I delve into the topic as such, I'd like to invite our minds to Ecuador back in 2020, just to give you a glimpse of what I am talking about. So in February 2020, a group of girls who lived in the country's northeastern provinces of Orellana and Sucumbíos filed a protection action, which is a constitutional injunction against the national government for authorizing glass flaring, whose polluting emissions contributed to climate change and also impacted people's health. The parent of one of the minors testified before the court. I have had cancer for about 5 years, and I have been fighting it. My daughter and I have to separate, given that I need to travel to another city to be treated because here in the province, unfortunately, we do not have an oncology specialist. We do not have any medication to fight against several diseases. And this is because the gas flares, they are making us, the Amazonians, sick. In January 2015, indigenous and Afro-descendant communities sued several agencies of the Colombian government for failing to prevent the pollution of the Atrato River. They argued that due to the mining activities and illegal deforestation and harsh climatic conditions, diarrhea, dengue, and malaria have proliferated. They denounced that the affected region lacked an adequate health system to treat and cure such detrimental health conditions. These are just 2 of the 32 rights-based lawsuits filed until mid-June in Latin America that are brought up, raising up issues of health and invoke the right to health as a means to tackle these interwoven issues. These 32 cases represent 52% of the total rights-based lawsuits in the region. Despite the proliferation of this litigation in the region and the overlap that is currently occurring between the right to health and climate change in courtrooms, little is still known about the significance and use of the right to health and how courts and litigants can better deploy strategies to fully protect these populations. So back to my initial point, to shed an initial understanding of what's going on the ground, I applied content analysis, drawing on Siri's analytical framework on the anatomy of the litigation process to really try to see the profile and the motives of litigants, the objectives, their arguments, and the legal basis. And the findings, really briefly summarizing, unveil a constellation of actors. However, based on how they claim and they invoke the right to health, how they frame their concerns, health-related concerns, and their objectives or their legal actions, cases can be grouped in 2 sides of the spectrum. So the first side, we can group them into cases in which claimants brought the social dimension of vulnerability because they themselves experienced this directly. as opposed to the second group, which are concentrated only on reducing greenhouse gas emissions. So for them, it seems like issues of poverty are not a direct reality. But what's interesting here is that there is a connecting thread between how these two groups of claimants framed their arguments and how courts understood their vulnerability. So you'll have that for the first group, for whom social vulnerability was pressing, courts ended up undertaking a contextual analysis and ordering redress measures focusing on providing healthcare services, as opposed to the second group, for whom courts decisions were more focused on tackling and mitigating climate change, really reducing the amount of emissions without actually laying a focus on the social conditions, of the pressing social conditions these type of groups are undergoing. So in sum, while all the analyzed cases invoked the right to health, as I mentioned at the beginning, they followed different trajectories based on who the litigants were, how they used this right, and thus how courts understood and sought to tackle climate change related effects. So for the second stage of this research project, I am willing to undertake a more in-depth case selection study so that I can really see why is this happening, and to unveil aspects that really go beyond the black letter of the cases and of the law. And as climate litigation continues to proliferate in Latin America and worldwide, these actors will be increasingly confronted with a myriad of complexities inherent to climate change in several connection with human health. And against such an exceptionally intricate challenge, how these actors use the legal tools, such as the right to health, but crucially, how they understand and frame vulnerability, is really crucial to decide whether climate litigation will take a new path towards a climate-safe development, or simply would replicate past mistakes of the legislative and executive branches. So I leave this complexity on the table as I pass it over to my colleagues, who are doing excellent research, because I do believe, as we all are in this room, as we all believe, that scholarly work is just essential for us to untangle this complexity. So thank you, Siri, for the opportunity. Thank you, Catalina, and everyone.
So thank you very much, Talia and Catalina, for sort of giving us this really broad but also in-depth picture of very sort of multiple trends and diverging trends and different ways in which we might not necessarily think about climate litigation, but addressing issues both of mitigation and adaptation. And then I have 4 excellent scholars who will come with their insights and interventions and give us some insights into their work as well. So first to speak is Carlotta Garofalo, who is a PhD candidate at the University of Graz, and will say a little and will say a little bit more about her work when she starts. Then we will have Giacomo Giorgini Pignatiello from the University of Siena, and Rafael Hutardo Valdivieso from the University of Central Florida, and Felicia Ikpo Conte from the University of the Witwatersrand, Dates University, and from Nigeria. So I was, of course, you could all speak for a long time, but I've only given you 5 minutes each. So take it, go with it, Carlotta.
So thank you very much, Talia and Catalina, for the wonderful presentation, and Siri for inviting us to this serendipitous panel. So I will follow up on Talia's presentation, talking a bit about my work. I'm focusing on climate change litigation in Europe. Most of the cases in Europe so far have been of the kind that Talia mentioned, so they are aiming to reduce greenhouse gas emission. They do have some hints at social vulnerability. As mentioned before, there are the cases that also talk about the health of the clima signorina, senior women, or young people, but indeed they are a bit different from cases mentioned in South America. So when I started this research, I noticed that cases were growing a lot. We talk about a wave of climate litigation in Europe after Urgenda, more than 40 cases being filed before supranational and national courts. And the interesting fact is that this is happening in countries whose governments claim to be ecological, like in Spain or in Germany, where strategic litigation is not so common, like in Italy, or where the access to justice is also not so broad, like Switzerland. So I've started wondering what are the driving forces of this litigation and who are the litigants, what is motivating them. And for this reason, I've used both legal methods and then ventured in interviews. So I've interviewed climate litigators from Europe, asking them these kind of questions. And I'd just like to share with you some of my early findings, observations. So one first myth that I stopped believing in somehow, or like an overestimation that they had done, was about the role of transnational legal networks in providing legal assistance. So these networks exist indeed, like the one created by Urgenda, and they are very important in motivating litigators and keeping the momentum for litigators around Europe, but they're not so important when it comes to providing legal assistance, given that jurisdictions in Europe are still very different from one another and climate policies are also different. Something else that sort of surprised me is that climate litigation is not as sexy, or was not at the beginning as sexy as it now looks like. So litigators in some countries really had a hard time actually convincing the legal community that climate litigation is not crazy. So to support them with legal assistance, or finding also social movements that would support them. Well, this of course has changed also throughout time as more cases have been filed, as the courts start reacting positively to change. Something else I've been interested in is legal strategies and how they are influenced by different legal opportunities and how they are not, or when they are not. So in some cases, litigators seems to take a little bit of a legal risk, and they, let's say, go for strategies that are not the most likely to succeed in court, and they do so also because they want to send a message. I think an interesting example of this has been the Belgian case, the Klimaatsak case, where the litigators decided to file a case on behalf of 50,000 people without arguing that they were individually affected. So the message there was climate litigation is affecting generally the population. Of course, there are differences of vulnerability, but it's going to touch everybody at some point. And also the Italian climate case, I don't know if you've heard about it, they're asking the state to reduce its emission by 92% by 2030. They don't think that the state will do so. They don't think that the court will take this argument, but they're doing so because they want to say that a developed country, if it wanted to follow climate justice, would have to reduce its emission by such a radical amount. And I go to conclude with one final observation that was stimulated by the conversation with J.K. Durgard yesterday about the role of rights in this litigation, because we're talking about rights-based litigation. So it's interesting to really try to understand what is the role of right in the success of these cases in court. And it doesn't seem to be so obvious to me. So there are cases where rights are important for the judges to enter into the domain of climate politics, where they are important to set some thresholds. But also there are cases where rights are not so important to understand what the duty of the state is. So my hypothesis would be that rights are not really understood yet as a source for individual entitlement. There is not yet this really right to climate protection, but they are a form of collective politics.
Then Giacomo.
So first of all, let me say a big thank you to Siri and all the people that are working so hard for making this Bergen Exchanges 2022 possible. My name is Giacomo. I'm a PhD student at the University of Siena in Italy, and I'm mainly working on the rights of nature. So today I would like to share with you some provoking comments and thoughts about climate change. So the ecological bankruptcy that we are facing is the result of a social ecological crisis that is deeply embedded in the social structure of our society. And I think it should be fair to acknowledge that law, and particularly administrative and international law, up to date as a means of social transformation has failed. However, in a more constructive approach, so more optimism, thank you, no need for that. Okay, I won't use my PPTs, it's okay. Has failed. However, looking in a more optimistic view, there's a layer. There are some countries, particularly those that have a post-liberal constitution, and namely a transformative constitution, that acknowledge the limits of constitutionalism and try to improve the conditions of human beings and all the living beings. And so their constitutions have the ability of reorient human rights. And this is the layer we should really take care of and look more deeply into. And I think judicial activism in the field of climate change is also very interesting. And I claim that nowadays, if we look at transjudicial litigation, their courts are creating some sort of a jus climaticum comune, meaning there's a shared constitutional discourse on climate change. And this is quite evident if we use a fresh tool to explore this transjudicial dialogue, that is the analysis of the use of foreign precedents by constitutional judges. And if we just look at the case of Germany, the Neubauer and others versus Germany case quoted 6 times the Netherlands case, 2 times the Irish case, 1 time the United States, and 1 time the even New Zealand. And German Constitutional Court is known to be one of the most reluctant courts in the world to use foreign precedents. And this tells us that there is this growing alliance among courts to protect to protect the environment and in general to stop climate change. So I think it's an interesting point of view to analyze climate change, this use of foreign precedents. And thank you very much. And yes.
Thank you very much, Siri. Thank you, Catalina and Talia, for your wonderful presentation, trying to trace the intersection between climate change and protection of the environment and health. I think it makes my work a bit easier, so I don't have to go about that. Then about the litigation, proliferation of litigation in different parts of the world. Thank you to the organizers of the Bergen Exchanges for this opportunity. So looking at the issue, for me, I'm coming from a different perspective, like from the Nigerian perspective and from the legislative drafting perspective. So we know that, as Makan said yesterday, the law can be used as a weapon of oppression and can also be used as a weapon of protection. And if we are talking about litigation, we know that we are talking about how we can utilize the law to protect either to protect our rights or to repress others. And so when we want to talk about litigation, it is important that we look at how our laws are framed, because it is the way that the laws are framed that determines how successful litigation can be. That was what motivated me into investigating how the Nigerian environmental legal framework impacts the resolution of oil and gas related disputes, especially between oil and gas companies and the host communities in the Niger Delta region of Nigeria. We are looking at this because it is very important. If we need to have access to the courts, we need to look at how the law grants us access. It is not just about saying we have a right to access the courts or we have a right to protection, but how can we exercise this right? And even when we have judgments in the courts, how can we enforce these rights, the judgments? Catalina talked about how even though people are engaged in litigation, it's as if the issues are still the same. Why are the issues still the same? Why can't we enforce the judgments? Why is it difficult to have successful litigation in some jurisdictions and then it is easier in some other jurisdiction to have success? Like the Nigerian situation, we know that most of the times there are cases that may fail in domestic courts because the people do not have a right or cannot prove their cases, or because third parties cannot actually access the courts to enforce protection of the environment. And then these cases are taken outside, maybe to the Netherlands, to the United Kingdom, to the US, and the litigants have success. Why are these things happening? And then that makes me to start thinking about how can we reform our laws to enhance the resolution of these disputes, to enhance access to justice, to enhance public litigation, and to enhance enforcement of judgments of courts. And to be able to answer these questions, I think we need to take a step further and start cascading down to the minor issues, or would I say to the micro level of how these things intersect. And that takes us beyond just going to court to enforce our rights and start unbundling our legal framework. How does each piece of legislation affect dispute resolution? How does each piece of legislation affect access to justice? How does each piece of legislation affect enforcement of judgments? And to be able to do this, we need to assemble a database of cases to know how each of these statutes or provisions of the law impact cases in different ways. So that's what I'm trying to do in Nigeria, to analyze, to assemble and analyze a database of cases. And then from those cases, we know how each legislation affects the right to justice, the right to health, the right to enforcement of judgments. And then when we know this, we can begin to negotiate, renegotiate, not just our rights to health, but our rules of engagement in litigation. It is when we begin to renegotiate these rules of engagement in litigation that we can achieve success in litigation. Without those re-engagements, having difficult conversations about how we can approach the courts, how we can enforce these judgments, it will be difficult for us to achieve success in climate litigation change.
Thank you, Felicia. That was a very fresh and interesting perspective. Rafael.
Hello. Well, thank you very much for this opportunity. I'm Rafael Hurtado. I'm from Colombia. I'm a student in the University of Central Florida. I'm in the second year now in the PhD in security studies. And I don't have a formal background as a lawyer. So for me, it's been a wonderful opportunity of learning a lot about climate litigation. Well, in my research, I'm more interested in maritime ecosystems and how the depletion of maritime ecosystems causes changes in coastal communities and how it affects the social cohesion and collective action. But for Bergen exchanges, I'm interested in how judicial decisions are important to protect maritime environment. I would like to talk a bit about the context of Colombia. In Colombia, we have 3,189 kilometers of coast. We have 12 departments and 47 municipalities that are in the coast. Due to its location, Colombia is a very biodiverse country, but in contrast, the population that live in the coastal regions is mainly poor. We have that is 56% of households in the Caribbean are under the line of poverty. And in the Pacific region is the 41%. We are in total 52 million of Colombians, and we have 5 million of Colombians living in the coastal regions. From that amount, the 33% are part of ethnic minorities, mainly African descendants, mainly indigenous populations. And what we have here is that the model of Colombian development is the centers of development are in the center of the country, are cities as Bogota, as Medellin, as Cali. And we have a very interesting case study about a sentence. It's a popular action that protects specifically sharks and rays in the archipelago of San Andres and Providencia. And this is important because it's a scientific-based decision. Why to protect sharks and rays? Because they have a very important ecological function. And if you protect sharks and rays, you will also protect many other species in the trophic chain. And a popular action is a mechanism in the Colombian law that is designed to protect collective rights. And this is a very good example. The information that I have until now from the persons that work in the 7 institutions, the seven institutions with a competence and with responsibilities over maritime resources and hydrobiological resources in the archipelago of San Andres and Providencia. They accomplish yearly this sentence, and they develop a series of actions year by year. And the information that I have until now is obviously something that I have to look forward more deeply, is that the sentence of the Council of State has been important to raise the awareness in institutions and to protect the maritime ecosystems. Why protect maritime ecosystems is important? We're talking mainly about mangroves and coral reefs, because these people that live in the coastal communities are mainly poor, and poor persons, I mean, poor communities in condition of vulnerability rely in the ecosystem services for not only for provision, not only for food, they also rely for regulating, and they are very connected with the ecosystem services in cultural values. So this is a good example. I would like to talk more about you, Professor, about this case. But in this case, I think it's a successful case when we raise the protection of maritime ecosystems and we cause a direct benefit in the community. Thank you.
Thank you so much. And of course, the case is concerning coastal communities, where among the early climate change litigation cases dealing with rights and adaptation, but also protection of coastal ecosystems. And we see that there are new ways of, more and more creative ways of dealing with that, and with more success. Thank you so much. This was mind-blowing. This was super, a lot. I've learned a lot, and I'm sure everyone has. We still have some minutes left. So if anybody wants to ask questions, you know the drill now. You should rush to wherever a microphone is. It's there. It's there now. You even have a... Yes, so you need to line up behind this microphone. There it is. Yeah. And then we'll ask all the questions, and then they'll get 30 seconds of lunch. Okay.
Yes, hi. So I was trying to connect what you have presented to yesterday's presentations about autocratic politics and the limits of judicialization. And it seems that in this context of racial capitalism and extractivism, which is the basis for what comes with the ecological transition, what is special about the climate litigation, and what can we expect from the future, present future? Yes.
Thanks so much for a wonderful presentation. My question is in relation to, we have the heavy emitters and we have the sufferers, the people who are suffering as a result of the heavy emission, but are not necessarily heavy emitters. I come from a region of that context. So in your analysis, what are the available institutional frameworks at the international level, and how can vulnerable communities in least emitting countries actually be able to hold accountable the heavy emitters for the adverse impact to human rights that they are facing at their own regional level? And in relation to the right to health, have you looked at the possibility of extraterritorial application of the right to health to hold institutions or to hold countries that are not necessarily the ones that were emitters, but that are suffering the possibility or the consequences of emission? You talk about Latin America. You've heard about the Inuit petition. So how can we use those possibilities with extraterritorial application of human rights to hold the heavy emitters accountable?
I think in a way that it's just to comment very briefly on the last one, I think it's in a way unfair to say the problems are still there. I mean, these are huge problems. So even if, I mean, we need to not sort of put, I mean, everything is important. But I want, you actually will have 1 minute each. And to pick whatever you think is more important to say at the end. And I will start at this end with Talia, and then I will just go around. And then after that, it will be lunch, an hour lunch. So even if we might go 1 or 2 minutes over, I think that's fine.
Thank you very much, Siri, and thank you all for your questions that really touch on the very pressing issues on climate litigation. I would say about the structural effects and the limits of judicial activism. In the case particularly of South America, there's a long-standing tradition around the new Latin American constitutionalism, to which Roberto is not really helpful. But that this question is really today, it's now around the transformative potential of courts achieving this progress. Even though I personally think that the beast can be held for a certain moment, for a certain amount of time, but it definitely, climate litigation has huge limits on bringing it down entirely. And then extraterritorial application of human rights, certainly that's a limit of the human rights framework itself. However, we do have from the international law perspective, the obligation of the so-called global north high-income countries to deliver international assistance to the so-called global south countries. And that it's really interesting because as people continue to file cases and bring these big corporations accountable and try to really push forward to bring about social infrastructure and health infrastructure, then countries in South America and the global south will be increasingly confronted with the question of increasing their investment. And that's where international cooperation plays in. Thank you.
Thank you. So I'll touch upon a little bit about autocratization and the limits of litigation. I certainly don't think litigation will solve any problem that we have in society.
No, no.
It is an important tool. It's part of the conversation. It brings about legal conversation, new arguments, no? The way we interpret norms, the way we see what are we missing, where we need to move forward. So that is certainly important, but it's not going to solve so nothing in climate change, because it's complex, nothing by itself is going to solve the problem. And this is true for all other complex problems. So that's a clear limit. I think it can allow or limit social mobilization depending on how it's used. But at least from specific cases, what I've seen is the limit, even if you, like, you know, very good cases brought to court in very creative terms and, you know, brings the judges to move their jurisprudence, their case law, to see things differently, to apply legal principles differently, to use case law from abroad, things that they didn't do before, even though we have in many countries, starting from my own, the problem of implementation of rulings. So, of course, courts help in, you know, balancing power to the political branches, but they cannot do all the job of the political branches. So they can give some orders, they can set some principles, but they cannot execute the law. They cannot be in the everyday business of managing the state. So this is a clear result that we see in the Atrato River with John. Beautiful ruling by the Constitutional Court of Colombia, protecting the rights of the ethnic communities, the territorial, the land rights, the ethnic rights, and also saying that the river has its own rights. Nonetheless, the river is very polluted. Legal and illegal mining are extreme, and many other problems are there. So that the limit is, yeah, you have a good ruling, but good luck with it, with the implementation. Then you really need to remember that you live in a state that is unequal, that you don't have a good representation in parliament, that you don't have a, yes, exactly, good government and all that.
So, but what you're saying is that it can be part of a moving towards a
Definitely.
conversation.
I believe it's an important part of the
and
conversation.
a democratic conversation, and that sort of that's in that context is important. I'm trying to be optimistic, okay?
Yes. In the case of Colombia, I think the Constitution of 1991 was in the Article 8 and in several articles states that the right of the people of a healthy environment, and it is very closely linked with the environmental issues. So in the case that I'm analyzing, I can see that legal mobilization of society can be very important in cause the social change, the social transformation. And I see that the Council of the State sentence was pushed by social groups, and this is I think, as I mentioned before, a wonderful example of how courts can be important in protection of environment and in protection of communities in condition of vulnerability. That's all.
Yeah, very good. So we are gaining seconds. I see from the countdown.
That's fine.
on the question about the impact of climate change litigation, I very much agree with what Catalina said, but also I think we have to take into account that litigation is taking time, so it's sometimes also hard to measure what the concrete impact is. Also, restoring nature takes time. When we think about river pollution, for example, but also when we think about changing a country's economy to reduce greenhouse gas targets, that requires a lot of planning. So we have to take that into account. And I believe that there are also interesting climate cases that might be more successful on a material level because the parties of the litigation are then involved in the process of implementing the case. And there are, in that sense, interesting Brazilian cases where you also have an autocratic government and political parties doing litigation and then being involved in the implementation of the court's order, but also in Europe. In the Urgenda case, actually, Urgenda was then involved into designing the new climate plan for the Netherlands. So I think these are the kind of cases that we have to look also to understand better what the concrete impact of litigation can be.
So very quickly, two main points about the future of climate change. I would say that global problems require global answers. So this emerging trend in transjudicial dialogue relating to climate change issues, I think it's very positive, and it conveys post-liberal constitutional values within the constitution, within the this emerging Ius Climaticum Europeum. So I see this. I think it could be seen more in depth. It's an interesting phenomenon, and more broadly about the socio-ecological crisis that we are affording. I think we should look more in alternative discourse, like the rights of nature, and look more to local answers. So more in the local with a global impact. Thank you.
Thank you for the questions. In my view, I think litigation, climate change litigation can actually change the narrative depending on how we are able to negotiate our spaces. So it depends on the kind of laws that we have. That will determine whether or not we can actually implement, maybe we can actually enforce the judgments or implement the climate change mitigation policies or adaptation policies. Those are some of the factors that will determine how far we can hold the oil companies accountable. Outside that, it may be difficult. And that is why we have issues now, because there are so many things that we've left undiscussed. We've not really negotiated these spaces. So the things is like we don't have a foundation for our policies. We don't have a foundation for the enforcement of our judgments. So if we are able to have good laws through which we can negotiate these things and know who is to enforce, who is to implement, how do we implement, how do we get the masses involved in the implementation and enforcement, then we can move forward with climate change litigation. But of course, we need to know that litigation is just a mechanism, not the only mechanism through which these things can be done. And if we have that understanding, then we'll begin to ask questions. What next can be done? In which situation can litigation be applied? And in which situation can other mechanisms be applied? And if we do the right thing, apply the right mechanism in the right circumstance, then we can have optimum results. And I think there's a question they asked about if the right to life has been used. I think in Nigeria, we have about 2 cases where the right to life has been used in litigation. But unfortunately, like in the Benre case, the court held that the constant flaring of gas is a violation of the right to life. But there was an order for the oil companies to stop gas flaring. But the gas flaring is still going on. Why? Because the government has a connection with all these oil companies. So who implements or executes the order? That's the question. So when we start negotiating these spaces, asking these questions, and holding our governments accountable through our engagement or participation, not just in public hearing, because there's a limit to which public hearing can help us, like to determine what happens in the drafting of a law. But when we go beyond mere public hearing to being really involved in the process of legislative drafting and decide exactly which language we are going to use and who is going to do what, then we can move forward. Otherwise, we will still be where we are. Thank you.
Thank you so much, all. Thank you so much.